After more than 10 hours, Parliament is voting on anti-fake news laws. The marathon debate on the Protection from Online Falsehoods and Manipulation Bill, also known as POFMA, started at noon. In his roundup speech earlier, Law and Home Affairs Minister K. Shanmugam addressed points made by some of the 30 MPs who've spoken on the issue over the past 2 days.
It's not a political exercise. It is an exercise to maintain our society and the values and have a set of honest debates on what should be the way forward, honest debates on social policy, honest debates on economic policy, honest debates on how we should structure society. But it should be based on a foundation of truth, foundation of honor, and foundation where we keep out the lies. That's what this is about. This is not about the Workers' Party or the PAP, or today it is about Singapore.
A heated debate took place earlier over who decides to take down fake news. Ruling party MP Cedric Foo said a ministerial decision would be quicker on occasions in which public interest is at stake.
Opposition MPs disagreed, arguing that the courts could be fast too. They referred to the Protection from Harassment Act, or POHA, where a new court would be set up to hear victims of falsehoods.
It is not my understanding that in cases of online falsehoods targeted against individuals and companies, POHA is going to present a slow response for these individuals. That process also can be quick. If not, there would be no provision for interim orders. So I disagree with this idea. The Workers' Party will stick to the point, and we believe that the courts actually can respond to online falsehood speedily.
You are a lawyer. I've been in practice. Do you think in every case that is necessary, the court can decide in a matter of hours? How long do you think it will take to get a duty judge? I'm sure you have tried. I don't know whether you have tried, but over 22 years I have tried several times. It can take 2 days. If the duty judge is in a hearing, it can take up to end of the day. It's not as if there's one judge sitting there doing nothing else but waiting for the government to come in and apply.
Is it the position of the Law Minister and the government that our courts could not be sufficiently resourced, structured, if necessary a new process, a new expedited process created, if necessary a new process for assigning judges created, additional capacity created? Is it impossible, is it inconceivable that this could be done in the future in order to issue interim prima facie decisions in urgent, time-sensitive cases under POFMA?
You believe that the courts can be used to make a decision to break the virality within a matter of hours, every single time, when it's necessary to do so. Is that your party's position?
Courts are sufficiently structured and resourced and the process is defined to enable that to happen? Then the answer is yes.
I've got the clarification I've needed, sir.
Now, this topic came up again later in the debate between Workers' Party NCMP Leon Pereira and the PAP's Murali Pillai.
Would that not be a further argument for the government, the state, the society to actually invest in developing judicial capacity and structures and processes even more for the administration of POFMA than what has already been done for the administration of POHA? We recognize that POFMA is dealing with actually more important societal, political issues as opposed to POHA.
You're talking about Supreme Court judges who are at the top of the game. And they really, they have security of tenure. I can't think of more than 10 people whom I can offer as candidates for judicial appointments in the Supreme Court. Because it's a very rigorous process. It's not easy to build resources that way. We need to be honest about the resources that we have or do not have.
Education Minister Ong Ye Kung says it is nearly impossible for academic research to run afoul of newly passed anti-fake news laws. This, as some academics voiced worries that the legislation will affect research work, which typically revolves around disputing facts.
He adds that he believes some are criticizing the bill in the capacity of activists instead. Tan Se-hui explains.
There are two kinds of research, according to the Education Minister. One follows an observation or experience-based approach to understand how nature works. And that's what A-star researchers are currently doing. Another is based on opinion, philosophy or interpretation of history and mainly practiced by researchers in humanities. Mr. Ong said that the new laws, also known as POFMA, will not apply to both. He said he received a letter signed by over 120 academics, both foreign and local, who worry there may be unintended detrimental consequences in the research field.
The only way POFMA comes in is if the research used false observations and data to start with. You fabricated the data, which prevents the public discourse from taking place properly. In which case, such work, I don't think it can pass the academic standards and professional standards of any decent university or research institute.
Mr. Ong cited the example of ongoing research that challenges conventional wisdom, saying that such works are embraced instead of being persecuted.
Let me try to address what I think some of the academics are really concerned about. I may be wrong, but I don't think it is about research. I think they are worried that POFMA will be abused and used to stifle political discourse in Singapore. Because not all researchers are just researchers. Most researchers may also be activists. Nothing wrong with that. But it is their activist role that some of these academics are voicing their concerns about POFMA.
Mr. Ong said that the law treats all activists equally and does not target academics. But he added that public discourse is getting more rigorous in the digital era, creating a more challenging climate for academics. And because of their standing as well-respected members of society, public expectations of them will be higher. Mr. Ong then reiterates that the new laws enhance and not diminish democratic public discourse.
Amid calls by MPs to engage social media companies, the Communications and Information Ministry says that it's closely working with tech giants to develop anti-fake news measures, and these will be included in the codes of practice. Errol Lim with this report.
The Communications and Information Minister said the bill contains a calibrated set of measures needed to fight falsehoods in the digital age.
Our present laws, which were mainly conceived in the era of print and broadcast media, were not designed to address the issue of online falsehoods. For example, there are powers under the Broadcasting Act, which regulates all broadcast content, to issue takedown notices and block websites for public interest or security reasons. However, in administering the Act, IMDA has found these to be blunt tools. It would mean blocking an entire online platform for a single falsehood.
In response to concerns about potential abuses of power, the minister cited the government's track record of 39 takedown notices under the Broadcasting Act since 1996. The ministry will also form a new POFMA office as a competent authority to administer the bill. It will come under the Info Communications Media Development Authority. The new office will advise the government on the available legal levers against fake news and how effective they'll be. It will also work on the codes of practice aimed at preventing the misuse of online accounts and protecting political debate from falsehoods. The new codes will include measures such as using verification methods to screen out bots and disclosing sponsors of political ads.
The competent authority will also work with the intermediaries to develop company-specific annexes to the codes. These annexes will clarify how each intermediary will operationalize the broad outcomes, principles and objectives of the codes, taking into account the unique features of each intermediary's platform, its existing systems and measures to combat disinformation, technical capabilities as well as effectiveness.
He also stressed the need to go beyond legislative measures.
Legislation is necessary, but it is by no means sufficient in the fight against online falsehoods. Ultimately, our first and most important line of defense against online falsehoods is a well-informed and discerning citizenry, equipped with tools to combat online falsehoods.
He said the government will continue to support ground-up efforts by the public to build up digital literacy.